But
a lot longer.
but no, to seriously, I've been coming out doing presentations for IREM for probably about 18 of those 20 years, and writing articles, and I love it. I mean, frankly, I'm a nerd, and so doing this stuff is a blast for me. So I appreciate doing it. I kind of wish we weren't talking about a pandemic, but hey, it is what it is. But there are so many cool ideas, so many cool things I've talked about over the years. It's just a lot of fun, and so I take what I do seriously. I don't necessarily take myself all that seriously, so I try and keep it lively to the extent I can. But it's good to be back in front of you guys, albeit electronically.
Albeit electronically. Well, thank God for the internet, right?
Yeah, exactly. Yeah, thank God. Yeah. So
well, I think you can start anytime.
Okay, well, I'll go ahead and get started. And if you guys have questions, feel free to put your questions in the chat room. I'll only answer the ones that I have answers for. If you don't get a chance to ask a question, we'll be able to answer and post the seminar. So don't hesitate. It's interesting that we're doing this seminar right now because as we speak, there are Dr. Fauci and certain members of President Trump's coronavirus task force are testifying to Congress right now this afternoon about the response to the coronavirus. They're doing it under the guise of learning about it, but as we know, it's DC, so it's largely political. But so you've got that backdrop happening right now as we speak. And then I heard this morning on the way in to work that that the U.S. overall, not just Texas, but overall, the U.S. is the 7-day average of coronavirus cases have surged from 30% that we were a week ago. So that's obviously not something we wanted to hear. It seems like just a few weeks ago there was a kind of a glow, almost a, I don't want to say euphoria, but almost a happiness because Texas started the reentry, other states started reentry. You heard about 2.5 million jobs. The May jobs report, when that came out, 2.5 million jobs were created, and so and so now that we're starting to have more spikes, is not good, not good at all from a number of perspectives. I know Texas never really had a first wave. Our cases were actually always pretty in check, but so I don't know if this is the second wave because we're actually higher than we were before. But nevertheless, we're spiking. And then you've got Governor Abbott, who last night was pretty vociferous in saying that business closures are the last resort. So we'll see how this goes. But I wanted to really talk about, there's so many things that have come up in the past 90 days that have legal implications from COVID. And there's so much misinformation and so much misunderstanding. I wanted to take some of these topics and kind of talk about them and try and clear up some of the confusion and talk about how they actually could like give rise to liability for building owners and managers, or could increase your cost, or ways you can maybe mitigate some of the risk. The first thing I want to talk about is this whole concept of force majeure. Okay, this is something where if you didn't know what it was 90 days ago, you probably at least have heard of it by now. But there's so much misinformation about what this topic really, really means. Force majeure is, it's really nothing more than just an excuse to performing under contract, okay? What does that mean? Well, let me give you an analogy. And I'm not trying to be gruesome or anything, but self-defense is often a defense to murder, right? If you're walking down the street and somebody attacks you and you fight them off and you kill them, then you're going to argue that I was committing self-defense. Okay, so self-defense is a defense to murder. Okay, well, the force majeure is a defense to performing a contract. Let me give you an example that dates back to 9/11. We had a client, we still have this client, and they are in the shipping business. It's a 3PL. And they were supposed to ship some very important goods that they were supposed to get delivered to them on September 11th, and they were supposed to deliver to their buyer on September 12th. Well, we all know what happened, obviously, and But the result was the airports all across the country, across the world really, were shut down for a few days. And the buyer, my client's buyer of the goods, sued because we never delivered them on time, and they and their downstream buyers all sued them, sued our customer. Well, fortunately, we had a contract for our client that had a really good force majeure clause that specifically said that if my client cannot deliver the goods because of an act of terrorism or because the airports are shut down, then we are off the hook. Okay. And now that was a very specific clause for a specific thing. But we did that, we didn't know about 9/11, but we did that because terrorism is out there, unfortunately, and air travel is constantly, being delayed. And so whether it's a thunderstorm or someone pulled the fire alarm or whatever, right? And so we had a specific defense in that contract that helped our client get out of a specific issue. And so the lesson from that is that force majeure clauses or force majeure defenses, these in Texas, these are clauses that are in contracts. Okay. And so you can't just argue force majeure and not have it in your contract. There are some states, Texas is not one of them, but there are some states that have what's called a common law defense of force majeure, but that's rare. Okay. Most states are like Texas, where there are no common law force majeure defenses. The only right you have in Texas is if it's in your contract. And like that 9/11 situation I described to you, it's typically a specific act that gives you defense. Okay. And so most leases will say that the landlord is excused from force majeure performance. So, and it defines what force majeure is, because there's no set definition of force majeure. Okay. The common definition, if you will, is just something that prevents you, something unforeseeable that prevents you from performing. Well, what unforeseeable could be anything, right? The power went out last night. My alarm didn't go off this morning. That was unforeseeable. Okay. But so the contracts that we enter into, like leases, will specifically identify what things are considered to be force majeure events. Most contracts now do not talk about pandemics. People are adding it now because that's a thing. But before, 90 days ago, when you looked at a contract, it really didn't say anything about pandemics in the force majeure clause. Now that's becoming a clause that people are wanting to put in these contracts. But you have to take it a step further, because in order for a pandemic to actually give rise to a defense of performance, the law says that the event has to have a direct impact on the performance. So the case I just gave you, we were not, my client was unable to transport those products. The products, by the way, the delivery address was the airport, airport in Atlanta. Okay. So we were unable to go there because it was closed. The government shut it down. Okay. And so that was a very specific event. If you look at COVID-19, if your force majeure clause says, well, we don't have to perform because of a pandemic, well, what does it really mean? I mean, does it mean that for the entire time there's a pandemic, you don't have to do anything? Probably not. That would be a pretty broad view of that contract. But my point is, if you're going to have a defense of force majeure, it typically has to be a specific defense that allows you to get out of doing something. So for example, if a tenant has a force majeure clause, it has to specifically say that they don't have to pay rent if they are trying to avoid paying rent because of COVID-19. Okay. But it goes beyond that. So we've had this come up a few times. We had it come up with a couple of restaurant tenants, and they said, well, because of COVID, we're not paying rent. And so I said, well, help me understand this, because, nowhere in North Texas were restaurants shut down. Okay. Restaurants were not open for dine-in, but restaurants could still work. They could still deliver. They could still have DoorDash, takeout, whatever. But the pandemic never actually shut you guys down. You never had anything that actually shut you down. You didn't have anyone test positive in your workforce. You had product coming in. So there was no real issue that came up for that tenant that they could argue was related to the pandemic. And so you hear this issue being thrown around, this force majeure issue, but really, it's not exactly easy for a tenant or anyone to argue force majeure gives them the right to stop performance. The other thing is that one tenant was basically arguing that they don't ever have to pay rent because of the pandemic. And I said, well, and their argument is because, we had this shelter in place order in Dallas County. And I said, well, what happens when the order's lifted? If to your argument, what happens when the order's lifted? And they said, we just don't have to pay rent. And so, so that obviously the argument didn't fly. We've ended up having to file a lawsuit against that tenant, and they have the burden of proof that that they don't have to perform. And I can tell you that they're not going to win that case. But nevertheless, so keep that in mind as far as how force majeure clauses go. Again, it has to be in a contract, and just because it's in the contract, it has to expressly allow the party who's trying to claim force majeure the right to get out of it because of some act. So keep that in mind. Okay, speaking of force majeure, I want to talk about building closures. Okay, this was a huge issue back in March and April, and I was hoping not to have to talk about it, but I think I need to talk about it because it's going to come back up again. It's already come back up again in the past couple of days because of all the spikes in the cases. But property managers and landlords have been calling me dating back to mid-March saying, should I close my building? Should I physically close my building? And the answer to that is a tricky answer, okay? Keep in mind that none of the shelter-in-place laws in Texas, whether the governor, city of Dallas, Dallas County, or anywhere else in the Metroplex, none of these laws shut down any buildings. The laws were specific to various businesses. For example, I mentioned restaurants. Restaurants were not allowed to have dine-in. Fitness centers and gyms were not allowed to have people in there. Okay, but there are some gyms that stayed open because they had a retail component to them. There are some spas that were not able to provide spa sessions or massages, but they stayed open because they sell product and they sell clothes or stuff, right? So buildings were not shut down. Certain businesses were limited from operating, but no businesses were legally shut down. So should you go ahead and shut your building down voluntarily is the question I'm getting a lot. The problem if you shut that, and the reason why people want to shut down is because they're concerned of the spread, okay? And I understand that there's a health and human safety issue, and I totally understand that. But if you shut your building down voluntarily, the problem you're going to have is that now your tenants are going to argue and say, wait a minute, I can't get access to my building, okay? I can't get access to the building because you, landlord, or you, property manager, you shut this down when you are not legally required to do so. And therefore, I'm not going to pay my rent, okay? So forget force majeure issues. Now the tenant's going to say, wait a minute, landlord, you told me that I had exclusive possession to my premises and I could operate it 24/7. Even if your lease doesn't say 24/7, the fact that your tenant has exclusive possession, if you voluntarily shut it down without a good reason, for example, your lease lets you shut it down for government regulations, your lease lets you shut the premises down for condemnations and casualties, but if you just voluntarily shut it down because you're afraid of COVID, now you're giving your tenants a good claim to sue you for not only not pay rent, but also sue you for lack of use of the premises, sue you for like a wrongful lockout type of scenario, wrongful eviction type of scenario. And so I would be very, very careful about choosing to shut down an actual business. Shut down an actual building. Now, there have been some scenarios, and this is rare, but there were some scenarios where there was a government mandated building shutdown while a building went through a deep cleanse, okay? And in those instances, I actually talked to a couple building owners when that happened, and most of their leases allowed them to shut down for condemnation or for some type of government action. And the lease allowed us to do that without fear of tenants not paying rent or without fear of the tenants suing us for breaching the lease. But that was but we had to actually look at that. I mean, we had to comply with the law, so we didn't argue with we didn't argue with the CDC about that, but we went back and we quickly looked at the leases to make sure that no tenant was going to sue us for that. But the key to that whole thing, I got to tell you, was, and I wish I could say who the property manager was, but they did a fantastic job of communicating all this to the tenants, and it was very transparent. They couldn't disclose who tested positive because you had to keep those things confidential, but they disclosed the fact that it was a very coordinated message. They were able to get it out quickly, and they had frequent updates, and it really did a good job of, I think not only mitigating it legally, but also giving everyone the confidence that the management was doing not only the right thing for the businesses, but also from a public health standpoint. So I hope we don't have to talk about building closures anymore. I hope that phase of COVID is behind us, but if it's not, I want you guys to have all the information. Another topic I want to talk about, kind of the opposite of closing down, is screening. People want to know, everyone wants to know, can I screen people coming into my buildings, or can I screen, from an employer standpoint, can I screen my employees? I've had a couple of landlords and property managers talk to me about screening for people coming into the building, okay? This has come up in a retail setting where you've got, like a big mall shopping center indoor where, people come in and you want to make sure that there's a lot of common area, and you want to make sure that they're not coming in and coughing all over the place. But for the most part, I'm not seeing too many landlords or property managers screen people as they come into the common areas. You're welcome to do it, but I'm not seeing it all that much. I think it could be something that does pick up. I think it's going to pick up momentum as we deal with this, quote, second wave. But so far, we haven't seen it all that much. But the answer to the question is, can you screen? And the answer is yes, you can, but there are some restrictions to it. I also want to point out that screening from an employment standpoint is different from screening from a building standpoint. So for example, if you have you as a property manager, or you as a vendor, or whomever, you have employees, and you have certain duties and obligations to those employees, and those are different from the duties that the property manager or the building owner has. So for example, employers, if you want to screen your employees, you're governed by the EEOC, the Equal Employment Opportunity Commission, okay? And so you have to follow their guidelines for screening. I actually looked at this a while back, 60 days ago, and I noticed that the EEOC came out with these guidelines in 2009, and I thought to myself, why would they do that? Well, as it turns out, the EEOC came out with these guidelines in response to the H1N1 swine flu that we had 11 years ago. And so so believe it or not, we've actually seen this before. We saw it with SARS, and we saw it with the H1N1. But the EEOC allows for employers to screen their employees as they come in. But you have to keep in mind that you have to keep it confidential. You can't release the results of the screening. If you want to keep a log or a record of the screening, you have to keep that confidential. And you cannot pick and choose who you screen. You have to screen all your employees. You can't just say, well, I'm only going to screen people on Monday, Wednesdays, or Fridays, or I'm only going to screen the men, or I'm only going to screen the women. You cannot discriminate. You have to, if you're going to screen everybody the same. So from a property management standpoint, if you want to start screening people, I would say the same thing. Do it uniformly. Don't random test. Screen it. Screen everybody. Keep it confidential. Keep it. From when I say confidential, I mean don't tell anyone. If part of your screening is, do you have symptoms or do you have COVID, and they say yes, you cannot disclose that. When I say confidential, okay. So just keep that in mind. Another thing to also keep in mind is, temperature screening has received a ton of publicity lately, but if you're really concerned about keeping your workforce or your building safe, I would not just limit your screening to temperature screening, because not everyone has a fever if they have COVID, and sometimes you can have COVID for a couple of days before you have a fever. So what most people who are serious about screening are doing, and I'm not saying you have to do this, but if you want to screen, I wouldn't just do the thermal screening. I would also ask the questions about, you know, how they feel, if they've come in contact with anyone who's been who has symptoms or who tests positive. You know, do the full questionnaire that you've probably seen. If you haven't seen, we can circulate it. But Governor Abbott in the Reopen Texas Act, he has a good screen where you can self-screen, or you can ask people for their conditions. One thing you cannot do is ask about their family members. You cannot ask if their family members have COVID, but you can ask if they've come in contact with somebody who has COVID or who has symptoms. You also, if you're going to be giving tests, people want to. I've had some clients ask me if they can actually give out COVID tests. So either the test for the virus or the test for the antibody. If you're going to do that, I would say that you've got to be careful because first of all, you need to know how to administer the test. And most people are not equipped to do that. The only reason why employers can give a thermal screen is because the EEOC has allowed them to give thermal screening. But even employers, that's all you can do right now. You cannot give a COVID test because that's considered a medical test. And unless you are a licensed practitioner, you cannot give out a medical exam. Okay, so if you're going to do any type of COVID testing, check with counsel first. Don't just start doing it. And if you do it and you have someone who's legally permitted to actually administer the test, like a nurse, you better make sure those tests are reliable, because you'll end up with too many false positives and too many false negatives, which does no good for anybody. Okay. Also, one thing to keep in mind is that you can ask employees if they've been traveling. You know, certain parts of the country have higher case counts than we do. You can ask your employees if they've traveled, and if so, where, and you can use that as part of your screening as the employees report back to work. See, I'm going to stop real quick, see if there's any questions in the chat room. No, okay, good. So, all right, so I'm going to keep going here. Another question that's come up is, who is responsible for social distancing guidelines? Who's responsible for doing all this? Well, this whole concept changed last Friday. So here, at least here in Dallas County. In Dallas County, as 11:59 p.m. last Friday, now pretty much every business is going to require masks for people entering that business. And the way the law works is that the business owner, if someone walks into your establishment and if they're not wearing a mask or face covering, you can ask them to leave or ask them to put the mask on. And if they don't, then the establishment can be fined. Okay. So the answer to this question about who's responsible for enforcing social distancing and enforcing that proper measures are involved, you know, a week ago, I would have said, you know what, it's not really your problem, but now it is your problem as a building owner. So as a building owner or building manager, you need to, or as a business owner, you need to make sure that when people walk into your building or walk into your business, that they've got the masks on, because you could be liable for it. As far as other social distancing, you should be very, very careful about this, because a lot of buildings, let's just take a typical office building or a retail building where there's common areas for people to sit and gather. You've got to be careful about this, because if you allow people to still gather in your building and don't maintain the proper distances, it may not be illegal per se, but if it's so foreseeable that somebody can get COVID-19 if they don't keep social distancing, if they don't wash their hands. And so if you don't have access to PPE in the common areas, if you don't have signs up telling people not to sit too close together, if you keep all the chairs out so there's plenty of seats available where people can sit close together, if you enable people to essentially violate the protocols, now you could be creating a situation where not only are you in violation, like for the masks, but you can create a situation where it's a premises liability issue, and I'll talk about that in a little bit, but where if somebody tests positive, if they can actually prove that they test positive from your building, that could give rise to a claim for failing to have a proper environment for your guests, for your invitees. So I'm hoping this makes sense to you all. But and I would say the same thing applies to a business. If you have a business, for example, my law firm, we are a business. We're open to the public. We have employees, obviously. As an employer, if I don't take the measures to have proper protocols for people so that they are allowed to sit and gather in a room a few feet apart, if they're allowed to touch common parts like copiers and refrigerators without proper PPE, if someone traces that back to me, to the firm, then I could be responsible for that. I could be liable for that. And so either from a workers' comp scenario or just from a pure liability standpoint. So this is serious stuff, and the contact tracing is starting to get better and better. I don't know if you guys are aware of this, but there are apps out there now. There's a few apps that you can download, and it will actually just automatically track for you based on other people who are using the app, whether or not you've actually come in contact with someone who has COVID. In a lot of other countries, this technology is catching on. I don't know how well. With people so afraid of Big Brother, I don't know how well it'll catch on here in the U.S., but in a lot of other countries, especially like Russia and Asia, this technology is catching on. But my point is, you got to be vigilant about whether you're an employer in your workplace or whether you're a building owner or manager in the common areas, to making sure that nobody's that you do not enable people to actually violate the policies. Let's see. Question that people keep asking me is, when can we re-enter? Is it too soon to have our workforce re-enter? It's a good question. Okay, I mean, for everyone's sanity, I would say it's never too soon. But I know that's not a serious answer. But the answer really depends. Okay, it depends on a lot of things. For example, it depends on where you are. Re-entry in Manhattan, Kansas looks a hell of a lot different than re-entry in Manhattan, New York, right? It's just you've got two totally different geographic areas. You've got two totally different ways that people live. New York people are gathered on top of each other. And so re-entry protocol and liability and risk there is different from a place like Manhattan, Kansas. But with that said, a lot of it depends on a balance of two things. You have to balance the health and human safety side of it for your employees and your customers, and you have to balance the what I would call the efficiency standpoint. If we're working remotely, is it just as efficient to keep working remotely for now because of the health and human safety factor? Or is it way too inefficient to keep working from home? Do we want to bring people back to the workplace? That's a question that only each individual establishment can answer. I did read a white paper that WeWork put out last week. I don't know if it's slanted, but WeWork, the research they did, they found that people are more efficient when they're actually working at the office. I think it was like a 60-40 split of people say they're more efficient when they come into the office. Again, I don't know if that was, I don't know how they gathered those results. I would suspect that WeWork would be inclined to encourage people to come back to their offices, obviously. But nevertheless, I think that's a decision you have to make from a business standpoint. From legal standpoint, I would tell you that there's a couple of things you have to keep in mind. You better have a proper reentry plan in place. You better have proper protocols for your employees. You need to have, you have to think of a lot of different logistical challenges. For example, if your workforce normally shows up at 8 o'clock and they start at 7:55, you've got 50 people at the elevators waiting to get to the floor. Is that really something you want to do? No. So do you want to stagger your workday? Do you want to have some people start at 7, some people start at 8, and some people start at 9? And then they would go to lunch and leave accordingly. do you want to have a common break area where everyone gathers and eats lunch? Maybe not. Do you want to stagger your lunch breaks? What about, having proper PPE? What about things like one-way hallways? Do you want people passing each other in the hallways, or do you want to have, only some hallways be one way so that no one's passing each other and breathing on each other? There are a lot of things to consider. In each, obviously each work environment's different, but it's something that I know when we did it for our firm, when we came up with our protocol, I sat down with some experts, some logistics experts, health and human service experts, to figure out what's the best way for us to properly do this. And we came up with what I think is a pretty good protocol. When we implement it, still remains to be seen, but we actually have the protocol. Let's see, I'm trying to think of another thing, anything else on that topic. Let's see, one other point I do want to make is, you have to be careful. Just keep your eyes out for this. I don't want to panic anybody, but one thing that I'm hearing a lot of buzz from a legal perspective is whether or not the EEOC is going to declare COVID-19 as a disability. And if they declare COVID-19 as a disability, that's got implications not only for business owners, employers, but also for building owners, because, as you guys all know, with ADA, there are certain things that you have to provide for people to have ingress egress. Okay. Now we are all familiar with that for people, for example, using a wheelchair, but how does it apply for someone with COVID? So I'm not trying to scare you or, create issues where there are no issues, but just keep this in mind that there's some buzz building about whether or not this is going to be a disability. And if that happens, then we'll probably have to have a webinar just on that topic, because there's going to be a lot to chew on there. Okay. Someone had a question in the chat room. I'll look at it. If I know the answer, I'll answer it. If not, so here's a question. The bars that were fined the last few days for not following restrictions, who exactly were the people videotaping and reporting them? That's a good question. There are, I don't know. I know that there are a lot of people who like to video, and there's like a whistleblower site for you to go and blow the whistle on some of these folks. And so I think a lot of people just take these videos and they submit them to these whistleblower sites. And a lot of, I know, like, for example, Clay Jenkins has been pretty vigilant about going after these folks. And I know, like, Mayor Johnson has as well. So I don't know who's actually reporting them, but I'm assuming it's people that are either, maybe it's the business's competitors. I don't know, but I presume it's people who are generally concerned about the safety of the community and are doing this for the greater good. I know Mark Cuban, actually, right after Texas opened back in early May, he hired some like private investigators and forensic people to go to various parts of the state of Texas to see which restaurants were actually complying. And he said that he did this because he wanted to help the governor out and help the people of the state of Texas. Maybe, I don't know if that's true or not, but maybe it was Mark Cuban who was ratting out all those bars. Sorry, I digress. I have nothing against Mark Cuban. I'm just throwing that out there. Okay. I want to talk about something now I'm sure that's just such a scintillating topic, and it's the topic of business interruption. This has come up so much in like the discussion about whether or not you can claim business interruption insurance because of COVID-19. And so generally speaking, it's going to be a pretty rare instance where COVID-19 is going to allow you to claim a business interruption damages on your insurance. And I'll tell you why here in a few minutes, but I want to just kind of walk you through the basics of what business interruption is. It typically replaces your lost income when your business shuts down for a specific reason. But it normally is tied to some type of property damage. So for example, last October, we had all those tornadoes that blew through Dallas. And in addition to the tornadoes, there were so many high winds that came through. And a lot of businesses had to shut down for days or weeks or months until they got rebuilt. And that would be a specific instance where, and that scenario is like your classic business interruption scenario where there's an act of God, lightning strike, tornado hits your building, and now not only do you have to rebuild your building, but you're out of work. You can't do anything, right? And so you have property insurance, and part of the property insurance will pay to rebuild your building, but most property insurance policies also have this business interruption component to it. So in addition to paying to restore your building, it would also, for example, pay for your lost profits. It would help pay for if you had rent that you had to pay, if you had a mortgage you had to pay during the time you're down, if there are certain loan payments to your creditors, typically business interruption would pay for that. Sometimes it pays for taxes. It would also pay for payroll if you kept your employees on the payroll during the time that your building was down. So certain things like that. What it won't pay for typically are, it typically doesn't pay for like utilities, because if your building's down, you're not using utilities. Typically it doesn't pay for off-book income or off-book expenses. So what that means is that you have to be able to prove and document your lost income. You have to prove and document your lost expenses. Let me put it this way: if your building got hit by a tornado, and you're going to claim that you were about to launch a new business line that was going to make you $10 million a week, you have to be able to prove that. Otherwise, you're not going to get coverage for it. Okay. So that's the basics of what business interruption covers. And like I said, it's typically tied to like some type of what they call direct physical loss. Okay. What is direct physical loss? Well, it's a term that's going to be defined by your insurance policy. And insurance policies are kind of like leases. They're not all the same. They might have similar components and similar concepts, but they're not all the same. The language is different in each one, okay? So you have to look at the insurance policy to see what it says. And also some policies are pretty vague, and so you have to look at what the law says in that state. And every state treats this differently. So it's very much a mishmash of scenarios here, okay? But typically, business interruption will cover direct physical loss. Like I said, the tornado, a lightning strike. If you remember back when Dallas hosted the Super Bowl, we had that snowstorm. We had all those roofs collapse. That's another example, okay? So how does COVID give a direct physical loss to your property? Well, it's going to be hard to find a scenario where that happens. We did have one client. It was the tenant of a client where this actually happened during COVID-19. It was a restaurant. It was a very high-end restaurant. I can't say the name, and two of their chefs, who are pretty prominent chefs, tested positive, and they had been working at the restaurant, and while they're working, they were there for at least a couple of days while they're positive, touching all the equipment, touching all the inventory, all the food. They were in close contact with plates, knives, utensils, napkins, menus, everything. Okay. And so what they had to actually shut down the entire restaurant. They had to throw away all the food had to be thrown away, and they had to do a deep cleans on everything. Okay, deep cleansing everything, and so that took about 8 or 9 days to get all that cleaned up. And so the tenant is making a claim against their business interruption coverage because there was a direct physical loss, because the COVID actually, they were concerned that the COVID actually contaminated the food, the equipment, all the restaurant equipment, the tables, the chairs, all the FF&E. And that is, since that's part of the building, part of what's covered by the property claim, that they're making that argument. I think the problem they're going to have is they have to prove that the COVID actually contaminated the food, right? They threw out steaks, they threw out vegetables. They actually go and check to see if that had the COVID. No. So they're going to have to get an infectious disease expert to give an opinion that it's likely that the food was contaminated. And so that's their claim, and that's what they're going to make. Whether they can prove it is another story, but that at least is a pretty good example of a direct physical loss due to COVID. Now, if that restaurant just shut down because they had no business, they're probably not going to get business interruption insurance for that. There are a couple of other instances where you might have a chance of getting insurance coverage for COVID. One of them is looking at COVID from whether or not it's like a pollutant or a contaminant. So let me back up. COVID-19 is caused by the virus called SARS-CoV-2, and there are some experts that consider that to be a contaminant or a pollutant. There are some insurance policies that will state that if your business is shut down because of a pollutant or because of a contaminant, then they will give you coverage for that business interruption. Okay. Now, after the SARS cases and after the H1N1 cases, a lot of this language in these policies was changed dramatically because so many people made millions and millions of dollars of claims because of this exact issue. And so nowadays, there are very few policies left that still allow this type of coverage. Nowadays, most policies will exclude contaminants from your actual policy, but you may still have some of these old language in your policies, or some people will buy additional coverage like a rider to their normal policy that that gives them this type of coverage. So I would say look for that as well. Another way to look at getting business interruption coverage is some policies have what they call a civil authority type of claim. So if you are forced to shut down because of a civil authority tells you to shut down without you doing anything wrong, then that could give rise to an insurance claim. Let me give you an example. Let's say you've got a business establishment and the zoning changes, and for whatever reason you're not grandfathered in. If you're required to shut down, that would be a civil action, a government order telling you to shut down when you didn't really do anything wrong. It's just because the zoning changed. So whether or not that applies to COVID, that's going to be a tough question, at least here in Dallas. Now, there are other states and other counties in other states where they actually physically said, no, you got to stop doing business. Texas took kind of a light approach to it where they didn't shut anyone down per se. They just basically said that, for example, restaurants, you can't have people dine in for a while. But there are some jurisdictions where they actually shut people down. And so if your policy has that type of coverage, you may be able to get there. But keep in mind, a voluntary quarantine or a voluntary sending everybody home to work from home is not going to be a civil action because you did that voluntarily. All right, let me see if there's any other questions here. Okay, good. So I want to talk real quick. Am I still a few minutes, or am I out of time? No. Okay, I'm talking. Okay, people. Another question that's been asked of me throughout the past few months is, what do we do with tenants that want us to help them with their reentry? A lot of tenants are calling up saying, "Hey, landlord, or property manager, how do I actually restructure my premises so that I'm poised for reentry?" I would be very careful about doing that because, first of all, that's not what we do. We're property managers. We're not in the business of logistically telling people how to structure their workforce. Okay, so I would not get into that business of telling them how to do it. I would simply tell them, and I've helped clients make some pretty simple, like 2-line responses to this, which I'd be happy to help anyone here do. Is basically just tell people that, look, you need to follow the proper guidelines and you follow the law, and this is a decision that you need to make after consultation with your legal counsel and with health and safety expert who's familiar with this, because you just don't want to go on the limb of advising a tenant about how to structure their workplace for a number of reasons, and COVID is just one of them. Be careful about the COVID world. It spins fast. Things happen so fast in the COVID world, unless you're stuck at home and you can't get out. But things happen so fast in the COVID world that laws change so quickly, and there's not a lot of good communication about these laws. For example, last Friday, when Clay Jenkins signed the order requiring masks, it was on the news, but no one really knew much about it, and there wasn't much advance notice. I mean, the order was signed at like 10 o'clock on Friday morning and went into effect at midnight. And so you got to really stay on top of this. I mean, you literally have to constantly not only watch the news, but I go to the state of Texas website, Dallas County, City of Dallas, Tarrant County, all the major counties in the north of Texas. I go to their websites every day to see what's new. I have all these Google alerts to see what's new, coming out of the stuff, because there's so much stuff coming at you so fast. So you got to be vigilant. It's almost like a part-time job of keeping up with all this stuff. The other thing you got to really be careful of from a liability standpoint, there have been so many conversations over the past few months informally with your tenants about rent abatement. Tenants emailing the property manager saying, hey, I can't make my April rent or March or May rent or whatever. I'll pay you back in July. And then we'll add on another month to the end of the lease. That was actually an email that a tenant sent to a property manager. The property manager responds with, okay. And so now that tenant has filed bankruptcy, and they shut down their location, they filed bankruptcy, and now we've got no protections whatsoever. So if you had any informal discussions with tenants about rent abatement or forbearance or whatnot, you don't let those sit out there without properly documenting those. Document them in an email, but it's got to be really clear what you're doing. It's got to be really clear what you're agreeing to. And even if you do it via email, I would still run it by counsel to make sure that it's in an enforceable agreement. So please be very careful about that. I've also looked at some memos that property managers want to send out to their tenants. This is very careful, because this could really build a huge trap from a lot of reasons. But I've had some property managers want to send notices to tenants saying that we are committed to providing a safe work environment. Okay, so I mean, I would never say that without COVID. Okay, but that's just a no-no. Okay, so you got to be very careful about making these statements. I think people want to help. They want people to feel safe, and they want everyone wants to help each other feel safe, right? And so people say things, they don't really stop to think what the consequences are. So be careful about making over promises, over commitments. Be careful about sending out statements that we have a zero tolerance policy for anyone who's not committed to practicing social distancing. Well, now you got to go out there and actually kick everybody out who's less than 6 feet apart, or if the mask slips from someone's face, you got to kick him out. Okay, so be careful about promising that. Okay, another topic we should probably, I talked about it earlier, I want to get back to it, is the whole premises liability issue. Okay, I've got a lot of clients who are asking me, well, if someone tests positive in my building, am I liable as a property manager if someone else also tests positive because they came in contact with that person? This is a great question. And anyone who's ever seen any of my discussions about handguns, I've already given you the answer to this question, because the same law that applies to handgun safety and active shooter safety applies to banana peels. It applies to COVID. It's premises liability. It's 101. It's the same thing we talked about when we talked about handgun safety. So, but it's different here, because from a premises liability standpoint, you as a landlord, you have a duty to keep the common areas of the building relatively safe from things that you know about. And if you don't do that and somebody gets hurt, then if it's foreseeable that they would have gotten hurt or sick, then you could be liable. Well, the difference between this and like the active shooter scenario is it's probably not foreseeable that somebody is going to walk into your building and start shooting up the place, right? But is it foreseeable that somebody is going to be positive for COVID-19 walks into your building? Yes. Unfortunately, I would say yes. With all the positive cases, with millions of people in the world who have COVID, is it foreseeable? Yes. With all we know about how easy it is for this disease to spread, is it foreseeable that that one person will contaminate other people? Yeah, that's probably a good argument, right? So if somebody tests positive in your common areas, if someone tests positive in your building, do you have a duty to keep your common areas safe? The answer is maybe. The answer is maybe. You probably do have a duty, but here's the thing. What is that duty? So here's what I'm telling people, and this really depends on the type of building you have. Let me give you two extreme examples. North Park Mall on one end, and the other extreme would be a warehouse building with one tenant, okay? So I've got lots of clients who have warehouse buildings and they're leasing 1 million square feet to Amazon. And Amazon's the only tenant in there, okay? And Amazon, as you probably all know, they are, they've got hundreds and thousands or thousands of workers testing positive for COVID, okay? Well, if you're a property manager managing that Amazon building, you don't really have a whole lot to worry about because there's only one tenant and there's no common areas. Let's say you manage North Park Mall or a busy shopping center or a busy building, okay, with a lot of common areas, with a lot of elevators, with a lot of, maybe it's mixed use, there's retail in there, whatever, okay? That's the situation where you've got to be careful about some type of liability. Now, like I said before, it is hard for someone to prove that they got COVID from your building, but let's just pretend that somebody wants to make the argument that they got COVID from your building. So what we're telling our property managers is from a protective measure, from a proactive measure, you should put your tenants on notice. I know this sounds silly because the whole world knows about this, but you should put your tenants on notice that it's likely that somebody is going to come into the building that is testing positive, that has COVID-19. And it's likely that this person may come in contact with common areas and other people. And therefore, you need to put everyone on notice that they need to practice social distancing, that they need to constantly follow the CDC guidelines about keeping themselves clean, that they need to self-screen, they need to do wellness checks in their premises, screening in their premises. You need to go on notice of telling everyone in your buildings that they have to be, that they need to be vigilant about this up front. Because by the time you find out that somebody tests positive, it's probably going to be too late, because by the time someone tests positive in your building, they probably already had contact with other people in the building. They probably already had contact with the elevator buttons and the doorknobs and whatnot. So by the time you figure it out, the cat's out of the bag. Now, I'm not saying that you do nothing once you find out about it. I'm saying that you should still do something about it, but I would be proactive about it and warn people, generally speaking, that they have to be careful about this. And if someone tests positive in the building, they need to make sure that they take extra measures in their premises so that there's no additional spread within their premises. Now, as far as the common areas, it would be best practices, and certainly it would help mitigate any risk if you did, certainly if someone tests positive, if you did a deep cleanse. And so I've seen a lot of property managers who are doing it even without someone testing positive, just because they want to be proactive about it. And they want to try and make sure that they go on record of saying, hey, we do a deep cleans every 10 days or every, once a month or whatever they're doing, so that they can sort of, for the record, go out there and say, we were trying to deep cleans as much as we could within reason. Now, the question is, who pays for that? And is that going to be an operating expense that you can pass through to your tenants? Most leases will allow you to do that. Some leases, again, you got to be careful, because some leases do not allow you to pass through expenses if it's related to a hazardous material. And I've seen some leases define viruses that cause contamination as a hazardous material. So be careful about that trap. I've seen a lot of folks say, well, I can pass this expense through, but I've got a controllable cap clause in some of my leases, and I can only pass through some of these expenses. And so we've got some clients we're trying to figure out creatively how we can get some of these expenses passed through despite these caps and these leases. So that's going to be an ongoing battle as far as how is that expense passed through. But for the most part, I'm seeing most leases allow you to pass through a lot of the expenses for these cleanses, these deep cleanses. I hope I'm making sense to everybody. I think that was pretty much all that I had lined up to talk to you guys about. I know it's getting close to 3. Are there any other questions, anything we need to talk about, or questions, comments, criticisms, smart remarks? No?
If there's no questions, hi, this is Z Young, president of IRM Dallas. Anthony, on behalf of IRM and the members that joined us today, thank you for taking the time to speak to us today on a very important and timely topic of mitigating risk for COVID-19 issues. I know I'm probably not the only one that's going to go and look at all of our policies and language on the direct physical loss and civil authority and containment. So those are my big takeaways. So I really appreciate that information. And once again, on behalf of IRM Dallas, thank you so much.
No, my pleasure. I'm glad to do it. I hope you guys got something out of it. If you have questions, I'm happy to talk about it. I know I threw a lot out there, and I talk fast. So if you have questions, don't hesitate to send them to IRM, and I'll be happy to get them answered for you.
I was taking a lot of notes. It was great information.
Good. I'm glad.
Tony, there are just a couple of them I think that didn't get covered. I don't know if you can see them or not.
I don't. What am I doing wrong here?
There was
maybe they send them to you privately, Kristen, because I'm not seeing them either.
That's possible, yeah. If you have a positive COVID and it's a multi-tenant floor, can you close the floor, or the tenant or the other tenants, is that on the floor? If you provide a mask to the person entering the multi-tenant office building, are you considered providing medical equipment?
Okay, I'll take the mask one first. That is not considered to be providing medical equipment. That's a good question. But I would be careful about providing the mask thing, because you got to make sure those masks are clean and sanitary. And so I would be really careful about doing that just in general, but it's not going to be a medical device. Now, when I say mask, I'm talking about like a cloth mask. I'm not talking about I'm not talking about like a specialized mask, but that just a cloth mask or bandana or something, that's not going to be a medical device. And what was the first part of that question?
I think it was basically if it's a multi-tenant floor, can you close the floor or close down the other tenants that are on the floor?
You mean because somebody tested positive? I would be very, very careful about doing that. When that's happened, and this has come up a few times, what we did, is we told the property manager, look, don't close the other tenant, don't close any tenant, but send an email. We send notice to the tenant immediately that says that they have, and the notice said, hey, you are solely responsible for maintaining your premises in good order, clean repair. We hereby demand that you follow the following CDC guidelines at your own expense to clean this up immediately. And if you don't, and this causes us to spend money or causes us to incur damages from somebody else, we're going to hold you responsible. And that tenant went out and hired a vendor, and they had a deep cleanse. We did not close the other tenant down. We closed the restrooms on that floor, and we directed them to go to another floor. And we had that tenant do a deep cleanse, and we asked the other tenant to pay for it. We could have demanded the other tenant pay for it, but my client wanted to be nice, so we asked if the other tenant would pay for it, and they said they would. But our lease clearly the tenant that tested positive, the tenant that had the positive employee, their lease required them to do it, but they voluntarily did it, and so we ended up cleaning the whole floor. So we did not close down any tenant, but we did, in addition to all that, we had a very, very carefully crafted notice to them, which we talked to them before we sent it, and we said, hey, we're not going to close you down, but we want you to consider the health and safety aspects of your employees and your customers. And so you may want to consider, if you, on your own accord, we're not telling you to do this, we're not asking you to do this, we're just saying you may want to consider on your own accord if you want to voluntarily shut down. And by the way, if you don't shut down and someone is positive and you contaminate other people in the building, you'll be held accountable for that. And so we didn't shut anybody down, but they voluntarily shut down for about, in fact, I think they're still shut down. One of them might have come back, but they shut down. So this happened a lot. So the answer to the question is I would not shut it down, but I would do something similar to what I just described. And whoever asked that question, I'd be happy to give you a more detailed synopsis of what we did. I ran through it really fast there, but that's how I would handle it.
Okay, there's just there's 2 or 3 more.
Yeah.
Okay, if we don't invite the general public into our offices in Dallas County, can we be liable for someone that comes to our reception area uninvited without a mask?
You know, here's the problem, is that this is another good question. These are all good questions. And I'm glad you asked them. And I was thinking the same thing. The problem is that the ordinance is so vague that it doesn't really say who exactly is covered by it. I would not want to take the chance of doing that. Okay, I would put up a sign that I would have a sign, even if you're not open to the public. I would have a sign on your door. And by the way, as a landlord, I know landlords, we get nervous about letting tenants put up signage, but I think we got to be a little relaxed on this issue, but that's another topic, I guess. But I would put a sign up, and I would ask that person who walked in unannounced to leave and cite the code, even though here's a tricky thing. Even though the person walking in does not have to pay the violation, every sign I've seen, it just says it's subject to a $500 fee. It doesn't say who pays it, okay? But most people don't know that, okay? Most people think, oh, I could be fined. They don't realize it's the establishment being fined. So the signs I've seen, and maybe I help some clients create them, doesn't actually say who's paying the fee. It just says there's a fee involved. So I've had them point to that sign and say, there's a $500 fee, okay? And then I would kindly ask them to leave. Keep in mind, you know, as long as you're not discriminating against somebody based on a protected class, you have the right to refuse service. It's like the old no shirt, no shoes, no service. No shirt, no shoes, no mask, no service. Okay, so that's a perfectly acceptable mantra to take.
There's another one, which this is a good one. Should management teams have Zoom meetings with their building vendors to keep from contacting? Is that a good idea?
That's a good idea. That's a good idea, and I would do that. In fact, when I was talking before about being proactive and sending out notice to all your tenants to be vigilant, I would send that same proactive notice to your vendors. I would, because your vendors are, from that standpoint, there's some of your tenants, I mean, they are and they're not. I mean, most of your vendor contracts will govern this, but the reason why I'm saying this is because some of your vendor contracts, the landlord has to indemnify the vendor for unsafe conditions at the building.
Oh, that's
so if your vendor comes on the premises and they get infected, are they then going to turn around and say, well, you failed to provide a safe building because your building had COVID. So I would be proactive with your vendors, just like I would be proactive with your tenants, and tell them that this is a situation they need to be aware of and they need to take the precautions when they come on the building. And I would definitely communicate that as best I can. A Zoom call is great to do that, but I also go on record of having sent that notice out. But yeah, I think that's a good idea. Look, the thing about this here's 2 things I tell people. Okay, there's so much dichotomy in this whole COVID thing, right? You know, people say, you got to go visit elderly people to keep them fed, but you can't go see elderly people. Pets can't get COVID-19 except for a couple of pets in Paris, right? So there's so much dichotomy back and forth. But so I'll jump on that bandwagon. The key to this COVID, getting through this, is dialogue and communication. The thing that's going to get you in trouble with COVID is dialogue and communication, okay? So you have to have good dialogue and communication with your vendors and your tenants, but you got to be very careful in what you say. Like I said earlier, you can't overpromise. You can't come out and say, we're committed to a safe work environment. So stuff like that is bad, but generally speaking, good communication is key, but it has to be good communication. You can't overpromise. You can't step into the you-know-what. So.
Well, there's one last one, and it's interesting. You might have sort of answered this, but it's what about the adverse health effects that wearing a mask has, such as decreased oxygen levels and have additional health and safety liability? Should there be some additional regulations and or exceptions in place?
That's a legitimate concern, because I mean, there are people that have respiratory problems or have asthma or whatnot, and just putting on a paper mask is problematic for them. And, so unfortunately for us as landlords and business owners, at least in Dallas County, they took care of that for us because they mandated it. And so I, as a business owner, if wearing a mask causes you collateral health issues because of some respiratory issue, that is a decision that you're going to have to make as a human being who decides to go out in the public. But if you want to go into my establishment or my building, you have to follow the law, okay? And so, and you have the right as a building owner, manager, or business owner to refuse service. You can tell them to leave. And so if they come in and say, I'm not wearing my mask because I have some condition, you know what? That's your prerogative, but you can't stay here. And so you can ask them to leave, and you are not going to be held accountable for that, because by law, at least in Dallas County, it's going to be different throughout Texas, but in Dallas County, you can ask that person to leave without fear of retribution. So, but that is a great question. These are all good questions, so I like it. Thank you.
Thank you so much.
No problem. Yeah, no
Really,
problem. My pleasure.
Great. We really appreciate it. Any last words?
No, I tell people, I have a sign, I forgot to bring it with me, but it says, keep calm and COVID on. So that's the one thing that I've told people throughout this whole thing is just try to do what's about you. I don't want to sound like every celebrity that goes on the TV. I'm not a celebrity, first of all, but you guys we'll all get through this. So just keep it with yourself and we'll all be fine. I hope. Right.
Thank you so much, Tony. That was
Thank you, Tony.
Yeah, thank you, folks.
Thanks, Tony.
Thanks again. I think this is a recording I'm gonna listen to again.
Good.
Take care.
Thanks
Hopefully,
everybody for joining. Y'all have a great afternoon.
Thank you.
bye-bye.
Bye.